Welcome to this training, Guardianship and Aging in Intellectual Disability, Case Studies, Part 2. This is a companion training to Guardianship and Aging in Intellectual Disability, Part 1. Now that you have an overview of the various types of guardians and their roles, let's take a look at some hypothetical cases to get a more in-depth look at guardianship. Margaret is a 60-year-old woman with Down syndrome. She's also showing signs of dementia. Recently, she took a bad fall, which resulted in fractures and a concussion. After a week in the hospital, she was discharged to a rehabilitation center before returning to her group home. She also returned to her day program, but it was soon apparent that her dementia was worsening. She was more disoriented and tended to withdraw socially and avoided community activities. Margaret's sister and brother are her co-guardians. Margaret's sister is very involved, but her brother lives far away and is uninvolved in Margaret's life. While Margaret was in the hospital, Margaret's sister signed a DNR order. Her brother agreed with this and indicated his agreement in an email to the attending physician. Now that Margaret is back in her group home, Margaret's sister wants to keep the DNR in place. However, her brother disagrees, since she is otherwise healthy despite the progression of dementia. Question: can Margaret's sister sign a DNR given the disagreement with her brother? The answer to this question is no. Margaret's sister cannot insist that the DNR continue once Margaret has been released from the hospital. For a DNR to be extended without the consent of both co-guardians would require a substituted judgment by the court. This is a decision made by the court on behalf of the individual. Let's meet Jim. Jim is a 72-year-old man who lives in an apartment with some support from a caseworker and home health aide. 4 years ago, he retired from a job as a dishwasher at a diner, and since then, he's been very involved with the senior center. Jim is legally competent. When he retired, he completed 5 wishes, an advance directive, and also appointed his brother as his healthcare agent. He was recently diagnosed with stage 4 colon cancer that has metastasized to his liver. He has opted not to undergo invasive cancer treatment. Furthermore, he and his doctor have put a MOLST order in place. His brother disagrees with Jim's treatment decisions and refuses to honor Jim's wishes. Question: does Jim's brother have legal authority to override Jim's treatment decisions so that Jim's wishes are not implemented as laid out in the MOLST form? The answer is no. Jim's brother has no legal authority to override Jim's wishes. A healthcare proxy must be activated by the physician only when the individual is no longer capable of making informed treatment decisions. Because Jim is still competent and capable, Jim's brother has no authority as a healthcare agent because the healthcare proxy is not yet in effect. Furthermore, if Jim has concern about his brother honoring his wishes, Jim can tear up the healthcare proxy and name another person who will carry out his wishes should he become incapacitated. If he has no one else to name as a healthcare agent, he has created a 5 wishes document and MOLST, both of which should act as safeguards of his medical treatment wishes. And let's meet Esther. Esther is a 64-year-old woman diagnosed with severe intellectual disability. She is nonverbal and needs assistance with all aspects of her daily activities. She resides in a group home after spending much of her life in a large state facility. Her 89-year-old mother has full guardianship and has been very caring and involved with Esther, as is the rest of the family. Several weeks ago, Esther's mother passed away, leaving her without a guardian. Esther's brother, who visits her regularly, had been planning to petition the court for guardianship, but before he could, Esther was hospitalized with pneumonia. Unfortunately, the pneumonia didn't respond to treatment, and it spread to her bloodstream, threatening her other organs. Her physician has asked the family if they would consider putting a DNR in place. Question: Can Esther's brother sign a DNR order if he is not yet appointed guardian? The answer is yes. There is an exception in Massachusetts law that allows a non-guardian family member to consent to a DNR order as long as he or she is a loving, involved family member. Under Massachusetts case known as the In the Matter of Dinerstein, the court held that a DNR is a question not for judicial decision, but one for the attending physician, in light of the patient's history and condition and wishes of her family. Therefore, Esther's brother may consent to a DNR order. Please note that this does not apply in the case of Margaret because even though her sister was involved, there are two co-guardians who disagreed. Irma is 76 and had lived and worked on her family's farm until her parents died. Her only sibling, a sister, lives out of state and is uninvolved in Irma's life, so Irma moved into a supervised apartment. Although legally competent, she never completed an advance directive, nor did she name a healthcare agent in a healthcare proxy document. Recently, she suffered a stroke that left her partially paralyzed and with significant memory loss, and she's no longer able to make informed treatment decisions. Question: who can make treatment decisions on Irma's behalf? Answer: this is complicated. If Irma is capable of making informed decisions, she may sign her own forms. If not, a clinical review team would need to evaluate her need for a guardian, and if so, what kind. If the recommendation is for guardian, then Irma's support team would need to petition the court for a guardian to be appointed. The team could also reach out to the sister to see if she could become involved in an emergency situation, either as a healthcare agent if Irma were competent, or as guardian if not. Let's meet Donald. Donald is a 67-year-old man with moderate intellectual disability. He lives in a supervised apartment with two other men. For years, he has worked in a day program run by the agency that also provides his residential services. Both of his roommates have recently retired, and Donald would also like to retire and spend time with his friends and attend activities in their community. His brother, who is his guardian, disagrees. He thinks that as long as Donald is able, he should participate in his day program. He worries that Donald would, quote, get himself in a bunch of trouble if he's not in a structured program. His case manager feels that Donald would enjoy the new social opportunities that retirement would offer, and sees no indication that Donald would have difficulty handling retirement. She has urged the brother to honor Donald's wishes. Question: could Donald's brother prevent him from retiring? The answer is yes. His brother has the authority to decide whether or not Donald may retire. However, Donald, like everyone under guardianship, is entitled to representation by his own court-appointed attorney. Under Massachusetts' Uniform Probate Code, guardians must act in the best interests of the individual, and if an attorney is appointed for Donald, he or she can question this on Donald's behalf. If the court finds that Donald's brother is not acting in his best interest, the court can override the brother's decision. They can look into the possibility of removing the brother as guardian and replacing him if a guardian is needed. They may also reevaluate Donald's need for a guardian and simply remove the brother as guardian without replacing him if a determination were made that there is no need for guardianship. And here's Mavis. Mavis is a 57-year-old woman with Down syndrome who has diabetes and dementia. Recently, she was also diagnosed with heart disease, and her physician has recommended that a visiting nurse come to her group home to monitor her increasing healthcare needs. Mavis's mother is her guardian. Her mother believes that Mavis should be moved from her group home to a nursing home to get more intensive medical care. Her treatment team disagrees. It is their clinical opinion that Mavis benefits from the routine of her group home, as well as the social support she gets from staff and her housemates. Furthermore, they feel that the visiting nurse will provide the monitoring and care that Mavis requires at this time. Mavis is unable to understand her medical condition, nor is she able to indicate her wishes regarding placement. Question: can Mavis's mother, her guardian, override the recommendations of the treatment team? Because Mavis receives DDS services, a referral for long-term placement in a nursing home would have to be made through an Aging Services Access Point, or ASAP. The clinical team recommends a less restrictive placement, and therefore the ASAP is unlikely to recommend that Mavis be placed in a long-term nursing facility. And here's William. William is 76 and has been living in his own apartment with a roommate since leaving Belchertown State School in 1983. Over the past year, William has experienced recurrent bouts of pneumonia and has been intubated twice, which helped but which he found very uncomfortable, and he decided he no longer wanted to be intubated. He is legally competent, and he and his physician have signed a MOST order that indicates that William does not want to be intubated again, but he would accept less invasive breathing assistance. One night, William had difficulty breathing. He called the area office nurse, who came over and arranged for him to be transported to the hospital by ambulance. The emergency responders wanted to intubate him, but when William refused, the EMTs were uncomfortable with using less invasive measures. The nurse handed them the MOST form, and they agreed to use continuous positive airway pressure, a less invasive way to assist someone in respiratory distress. Question: were they correct in their actions? The answer is yes. William is competent and has signed a MOST form, which is in place, stating that he does not want to be intubated. It was his right to refuse intubation, and the nurse was correct in sharing the MOST form with the EMTs. Because William is willing to accept a less invasive treatment, the emergency responders were correct in using continuous positive airway pressure. This is one webinar in a series on end-of-life planning with and for individuals with intellectual disability. These trainings and other related trainings are also available on our website or the DDS website. Thank you.